right, well, welcome back. As you know, we often try to return to evergreen issues in civil justice, and the admissibility of expert testimony is certainly one of those. It's also one, though, that is constantly evolving, or I think as some of the panelists might say, we are reminding the courts of its past evolvement, or past evolutions that it's taken that might not have stuck. And so part of that is, I think, part of the discussion that will surround recent changes to Rule 702. But there's also something new about what we want to focus on, at least for part of today's panel, and that is the extent to which the recent efforts at reforming the federal rules of evidence are creeping into reforms in the states, or what an analysis as to whether or not those reforms even need to occur in the states at all, or if the states have gotten it right in some way or another. You are certainly that laboratory of experimentation out there in the states, and I think we'll get some great questions from all of you and insights from your courts that will inform the discussion that our experts will be presenting up here today. We're honored and delighted to have Michelle Childs, Judge Michelle Childs, with us. Judge Childs was first appointed in 2006 by the Assembly in South Carolina to serve on the state court. And then in 2010, she was appointed to the U.S. U.S. District Court for the Southern District of South Carolina. And then in July 2022, she was appointed to the U.S. Court of Appeals for the D.C. Circuit. And Judge Childs is also a member of the Advisory Board, the Judicial Advisory Board for the Judicial Education Program. Thank you for your service in helping us there. She received her undergraduate degree in management from the University of South Florida Honors College, a law degree from the University of South Carolina School of Law, a master's in personnel and employment relations at the University of South Carolina's Darlis Moore School of Business, a master's of judicial studies at Duke, and an honorary doctorate degree in public service from the University of South Carolina. Before joining the bench, she was in private practice as well as serving as the Deputy Director of the South Carolina Department of Labor, Licensing, and Regulations Division of Labor, as well as the Commissioner of the South Carolina Workers' Compensation Committee. She's very active in the ABA and in ALI and other service activities, and we are delighted to have her leading us through our expert testimony discussion this afternoon. Judge Childs.
Thank you, and good afternoon. And it's so wonderful to be back here. I know we have a lot of state court judges. I'm always affiliated with you all because I know that's where the rubber meets the road in the judicial system. So we definitely appreciate all of your efforts. Well, this is going to be a fun, interactive, engaging panel. And why do I say that? Because we've got some experts here who are on our panel, but they know that we will get into very provocative discussion because they don't agree. And that's exactly what we want, because we want you to be open-minded about some of the things that they state, and we'll offer you that opportunity for questions. So the way I'll start this is we'll have a PowerPoint presentation, and then the other panelists will have the opportunity to comment and then provide any opening comments. Then I'll do a Q&A, and then of course we'll allow you some opportunity for that Q&A. So to begin with our panelists, we have David Bernstein. He's a professor at George Mason University, this Antonin Scalia School of Law, and the executive director of their Liberty and Law Center. He's been at George Mason since 1995 and teaches con law, evidence, and products liability, and has authored and co-authored several books and written dozens of law review articles. Alex Dahl is general counsel for Lawyers for Civil Justice. He has been the corporate and the defense bar as well with respect to these reforms of the civil cases and securing the just, speedy, and inexpensive determination of every action of the civil case. And we all need to resort back to Rule 1 as we think about this discussion. He has also served in various branches of the federal government, as well as working in private practice as a lobbyist and civil litigator. Eric Lasker is a partner at Hollingsworth, LLP. He has been featured in Law 360, The American Lawyer, and Bloomberg News. He litigates a wide variety of complex civil matters with a focus on toxic torts, environmental litigation, and pharmaceutical products liability. He's also represented several clients as lead counsel in multi-district litigation, mass torts, jury trials, and bench proceedings. And then also Douglas McNamara is a partner at Cohen, Milstein, Sellers, and Dahl, PLLC. He focuses on litigating complex multi-state class action lawsuits against manufacturers and consumer services providers such as General Motors, MGM Resorts, Marriott International. And then he reminded me, although I had not forgotten, that I had appointed him in one of the largest data breach cases in the nation that I had as a federal trial judge before I left to go on to the appellate court. And so I was catching up with him on that, and we'll hear enough about that discussion because it does have implications here with all of the experts in that regard. Now, the ABA has given credit to Professor Lasker and Professor Bernstein, essentially, about this topic coming up with respect to the amendment of the rules, because they had put out a law review article some time ago kind of challenging Dahlberg, kind of doing a little bit of criticism of it, and so they were starting the impetus of this particular rule. So we've got the people who actually performed or brought us to this discussion. All right, so we'll start out with our PowerPoint.
That's me, I guess. Do we have a clicker?
Yeah, right over here.
I'll just go up here, I guess.
Here you go. Here's a clicker for you to use at your seat.
Thank you. Back here. So we thought it'd be useful to start the discussion just by giving you a history of how we got here, why the rule is about to be amended in the federal courts at least. And the issue here actually starts back in 2000. This was after just the Daubert trilogy had been issued, which were the 3 Supreme Court cases that sort of laid out the gatekeeping responsibility that courts needed to adopt with respect to expert testimony, and that has been incorporated now in most of the states to one degree or another. There had been those 3 decisions, and there was a division that was already forming within the courts about how to interpret that case law, whether it actually liberalized the admission of expert testimony as compared to the old Frye rule, or whether it was requiring a more stringent test for admission of expert testimony. And the advisory committee to the Federal Rules of Evidence back in the late 1990s looked at this divide, and they made a decision that they tried to incorporate in the rule as was amended in 2000. And this is language on the screen of what the advisory committee stated in some of its working papers, which was, we are going the path of the more stringent application of the rule. They drafted the rule in such a way that they had hoped to guide judges to a checklist of things that courts needed to do before they would admit expert testimony and make clear to them what their responsibility was under the then newly amended Rule 702. The problem is that a lot of courts didn't get that message, and there continued to be this division between courts as to whether or not Daubert and Rule 702 was actually a liberal rule for admissibility of expert testimony, or was a more stringent guideline for judges as to what they needed to do to screen out unreliable expert testimony in the courtroom. And in the early 2010s or so, there were a number of Federal Circuit Court opinions that bubbled up that, at least from some of our perspective, was not applying Rule 702 the way it had been intended to be applied. And that's why Professor Bernstein and I got together and wrote the law review article we wrote in 2015, which was identifying this issue. We went through the legislative or the drafting history of the 2000 amendments, explained what the advisory committee had intended to do, explained the fact that lots of courts still had not understood what they're trying to do. Professor Bernstein will talk about some of the ways that courts got confused by this. We sent out this law review article. You throw it out there and hope somebody reads. In this case, the advisory committee did read that law review article, and that triggered what, as you can see, was a very long process of deliberation among the advisory committee with lots of notice and comment, lots of roundtable discussions, what have you, through a very long process in which the advisory committee determined that the rule needed to be amended again so that it'd be more clear for judges and courts since there had been such confusion over the last amendment. So this is the language of the amended rule. The highlighted parts are what is changing and what the advisory committee determined would allow judges to better understand what their responsibilities are under Rule 702. And I'll walk through the two changes for you. The first change goes to the issue of whether or not judges are supposed to weigh the evidence or are supposed to allow juries to weigh the evidence. We all think about the fact that evidence is something weighed by juries, and lots of courts in this 702 analysis were saying, well, what the reliability of what the expert is doing, that really goes to the weight. That's something for the jury to decide. What the advisory committee explained, and they tried to explain in 2000, and they were even more express in 2023 with the new amendment, is no, this is a role for the judge. The rules of evidence require a proponent of any type of evidence to establish the foundations by a preponderance of the evidence. Same thing applies for hearsay. Any other evidentiary rule applies with respect to expert testimony as well. So the first change the court, that the advisory committee made, was to make clear to judges, you have to weigh the evidence on these four standards, each of these four elements of Rule 702 that are laid out. And for each of those elements, you have to determine, more likely than not, by preponderance of the evidence, that the proponent of that expert testimony has established that their expert has met that criteria. And the court needs to do this. It's not something for the jury, it's something for the court. The second change goes to the last element, which is element D, which is the hardest part of Rule 702, I think, for most people who are not experts themselves, and for judges, when you're faced with this issue of expert testimony. Determining whether or not the expert is an expert in the field, that's kind of straightforward. Whether they have facts, you kind of feel comfortable with that. Whether they have a methodology that they can explain that's been applied, that's kind of doable. But then there's that last step of determining whether the expert has actually applied the methodology in a proper way. That seems daunting to a lot of judges because they're not scientists, and how are they going to determine whether the expert's right or wrong? But what the rule provides is you don't have to decide whether they're right or wrong. You just have to decide that they're following the methodology reliably. Whatever the result is, that's the expert's determination. But if they have a methodology, they have to actually be reliably following that. And the new amendment makes clear that, again, that also is something courts need to decide by preponderance of the evidence. Now, the other thing that is important that I want folks to understand, in various states, there's different ways that rules are amended. In the federal courts, there is a committee that is set up that is constantly reviewing the rules, and there's one for the rules of evidence, and that is their task. They have regular meetings to look at all the rules of evidence, and they have to determine whether or not rules of evidence require amendment or not. And they go through a pretty extensive deliberation process in which they debate the various issues, and they set forth the reasoning for what they decide to do. The first place you can look to for the reasoning of the committee is the advisory committee note, which appears right after the rule in the books on rules of evidence. And those committee notes are authoritative in themselves, or at least accorded very significant weight. There's lots of case law that discusses the fact that you should give great weight to what the advisory committee is stating. It's not like it's legislative history where you have people on both sides debating things and you can find a snippet from one part or the other part. This is one committee explaining what this rule means, and courts have recognized that is entitled to a significant weight. What does the advisory committee state in its note? And this is pretty important because the advisory committee was pretty explicit in explaining that there were a lot of courts who had gotten it wrong, who had been applying Rule 702 incorrectly for decades. Now, what does that mean for judges? That means you got a whole lot of case law out there, and even case law that is in your court and is in a superior court that's above you, that you would think is authoritative, but is actually wrong, and has been called out as being wrong by the advisory committee, and certainly should not be followed under the new rule. There are a handful of cases now that have interpreted the new rule that's about to come into effect, but there isn't a lot of case law on this new rule. So this is a new departure, and the old case law is not necessarily going to be helpful for you in this. So there are a number of statements the advisory committee makes in this note. Reminds judges they have to look at each of the individual elements that are set forth in 702. It's a checklist. You can go through it just like you do any other evidentiary rule and make sure that the proponent is meeting all of those elements. And then that last part, of course, which is the challenging one, is that judges do have to make sure the expert's applying their methodology in a reliable way. You know, Rule 702 is a lot of times seen kind of as separate from other evidentiary rules, but it really isn't. You don't want hearsay going in front of a jury because it's not reliable. You have ways of checking that. There's other things, eyewitness testimony. You have rules to make sure that jurors only have reliable evidence in front of them. It's the same task under Rule 702. More complicated, more daunting perhaps, but it is at least as important, if not more important, in civil and in criminal litigation. There frankly are lots of people in jail right now who probably shouldn't be in jail because of this. For my clients, I think that there's issues with unreliable scientific evidence on the civil side as well. It's a very important job you guys have under Rule 702 to address that. In addition to the advisory committee note, as I mentioned, there are working papers, there are memorandum the advisory committee put out. They also have a lot of information, likewise, in this case, pretty much calling out courts that have gotten it wrong. They actually discuss individual cases and say this case is wrong for this reason, and you can actually assess, and I don't know that you guys should be doing it, the attorneys should be doing this. They should be pointing out to you if the other side is relying upon a case that the advisory committee has expressly stated is wrong. That's something you guys should know. There is one, here's some of the information the advisory committee, that appear in the advisory committee working papers. One thing I would point out to you as a worthwhile read, Judge Schroeder, who was the chair of the subcommittee of the advisory committee that amended Rule 702, he actually wrote a law review article in, I think it was the Notre Dame Law Review, I can't remember, in 2020, in which he walks through the case law and walks through individual cases and points out which cases are getting it right, which cases are getting it wrong. As you can see, he was pretty sharply critical of the Ninth Circuit as being a circuit that pretty consistently got it wrong. That's not, again, a political view one way or the other. It's just as applying Rule 702 as it was supposed to be applied. So that's sort of the background of what's happening. I think that's the end of the slides. Here's 3 cases that the committee called out in particular that you'll often see relied upon. I think Professor Bernstein will talk about these cases. You'll note that they're before 2000. Some of them are before Daubert even was handed down, that courts are still relying upon for some reason, although they're clearly not current law. So that's the slideshow.
All right. I believe you were going to go next.
Okay, am I up? Could I go back to the slide where the amendment, your first one with the
Sure.
amendments? That'd be great.
Can you pull the?
Yes.
Okay, while he's pulling up the language of the amendment again, I'd like to point out what I think are the 3 takeaways and from the amendment. The first one, and the most important one, is that the court has to decide on admissibility. And I think that this goes really fundamentally to the problem that the Rules Committee took on, which is that judges in certain areas, jurisdictions, were, instead of doing the 702 analysis, just saying, I'm going to let the evidence in and let the jury decide whether it's helpful or useful. this amendment and the note say that that's not enough. Perfect. So that top line in yellow that you see contains the words "the court," and the reason it's there is for this reason: the court has to make the admissibility determination before giving the evidence to the trier of fact. It is not enough to say, perhaps, there are two experts, one on each side. We're just going to let the jury decide which one is more important. Everything that gets admitted to the trier of fact has to meet the 702 standards. So that's number one. The second takeaway is that the profferor's burden to show adherence to the standards of 702 is the preponderance standard. Number three, the bottom edit there, is that the gatekeeping burden of courts is ongoing. What this means is that a decision that an expert can testify is not the end of the analysis. You have to listen. Everything that comes out of the mouth of the expert has to meet the standards of Rule 702. So this obligation continues, and there's lots of information about this in the history of the rulemaking about why that's important, that there are experts who will lay out their methodology and the facts of the case, but then ultimately opine to a degree of confidence that is a lot higher than their science or their technique actually supports. You'll see in the notes to the amendment that this amendment is absolutely meant to change practices. As Eric said, their law review article, the article we were talking about, and the committee's work indicated, found a number of cases that were not following the requirements of Rule 702. One reason, and this is something that Lawyers for Civil Justice added to the discussion, is we went back and looked at what we called the DNA of the modern cases. And what we found in a lot of instances is that the language used in the current case law actually predated not only the Daubert case, but the 2000 rule. And we could see from case to case that one case quotes another that quoted another previous case and another previous case, and essentially the holdings of those cases continue to be in effect even though the rule has supplanted the standards. The note says that this is a clarification of the law. The reason I'm mentioning that the amendment is meant to change practices is to understand this difference. It doesn't change the law, but it is meant to change practices, and that is because many courts have been relying on pre-rule and pre-Daubert case law rather than the requirements of the rule. So that's what the rule amendment is meant to change. Judge Childs mentioned that we were talk some about states as well. I believe that almost all of your states have a state law equivalent of Rule 702, and in most, if not all of those cases, the same dynamics exist under state rules that led to the federal amendment. There is now going to be, if it hasn't started yet in your state, it has in several states, a review of the state standards for admissibility of expert evidence. And in many cases, I think that the states will end up adopting something that is similar, if not identical, to the federal amendment as appropriate, modified as appropriate for individual state interests and state rules. One of the overarching ideas that I'd like to share is the language itself about Daubert. And as you all know, this topic of expert admissibility is known as Daubert, or Daubert, depending on how you pronounce it. People say Daubert hearings, Daubert motions, we won on Daubert, we challenged Daubert, that kind of thing. My organization, Lawyers for Civil Justice, did research, and we read every federal case decided in 2020 that had anything to do with expert admissibility. And we found that 65% of those cases didn't refer to the standard that was being applied on that topic. We think that one of the main reasons why is that people think of this as Daubert rather than Rule 702. It's a very sloppy use of shorthand because Daubert is not the last word on the topic, and because of the way the federal rules system works, it goes through the Supreme Court and Congress. 702 is the law, and it is more appropriate to call these Rule 702 hearings and motions rather than Daubert. And language in our profession matters. It distracts people and makes them think of a different standard than what is required. So many resources are available on this topic if you are looking at your state rules or want to understand more about the history of the federal rule. And you can find these at the website that's called don'tsaydaubert.com. Lots of resources there about the rules, articles, and other things. So I hope that's useful to you as you examine your own state rules. Thank you.
All right, we'll next have Professor Bernstein.
Thank you. I pretty much agree with almost everything that Alex and Eric said. So I thought I'd spend a few minutes talking about why judges have been reluctant to apply Rule 702, not Daubert, Rule 702. I've been on about that for years also. That which is what led really to this clarification that judges weren't applying the rule. And I think there are a few factors here. First, contrary to the popular belief that was in part due to the Supreme Court misstating the law in Daubert itself in 1993, the rules for expert testimony through the 1980s in almost all cases, in almost every jurisdiction, was that if you were a qualified expert, you were testifying on a relevant topic that would be helpful to the jury, your testimony got in. So older judges were trained in that, were used to that, and it was really a drastic change starting in 1993 to say, no, actually, we have to apply a reliability test. Relatedly, and this goes to what was said before, a lot of judges were used to treating this as a common law matter because Rule 702 said so very little explicitly on admissibility until the 2000 amendments, and you would see cases from the 2000s where a judge would cite a case from the Third Circuit from 2002, which would in turn quote a case from 1996, which would in turn quote a case from 1985, and they'd cite that as circuit precedent, and they ignore the fact that there was a rule out there, much less that there were Supreme Court opinions out there also before the rule, and that just struck me as weird because 1985, you might as well be citing Roman law as far as expert testimony goes, as far as how up to date it is, but that was the case. One other point is that really expert testimony wasn't that big a deal in courts until the 1980s. Forensic science really took off starting in the 70s, but really became prominent in the 1980s. Toxic tort cases became prominent in the 1980s. So one reason why we had all this tumult about expert testimony is that it actually became this really significant issue, both in multi-billion-dollar cases and in lots of criminal trials. And before that, your typical case involving experts might have been a medical malpractice case where the only real issue was the doctor adhering to the local standard of care, which doesn't require any deep dive into scientific evidence. So the other reason, though, so that's like sort of cultural reasons why judges were reluctant. Of course, they're also concerned about whether they have the resources and skills to do this, but also I think that both the Daubert trilogy and Rule 702 as amended, and even today as amended again, judges, the Supreme Court and the Federal Rules Advisory Committee have not done a great job of articulating why we need special rules for experts. the Dauber case was just like, well, that's how we read Rule 702. And the advisory committee said, we're just following what the Supreme Court said and making it a little stricter. But you have to wonder what the underlying problem is. Judges are used to thinking themselves, as I'm sure you generally do, as referees or umpires. We're calling balls and strikes, penalties, and so forth. But we're not interfering in litigation. Deciding that a plaintiff's case or the prosecutor's case needs to be thrown out entirely because their expert testimony isn't reliable seems to be a lot more interference in the adversarial process than judges are used to. And they say, after all, we do let in a fair amount of unreliable evidence. That's one little disagreement I have with Eric. We do allow an eyewitness testimony, even though it's often kind of dubious. We do allow other types of testimony, hearsay. Some of the hearsay exceptions, frankly, there's no real, I tell my students in evidence, there's no real empirical evidence this hearsay exception makes the hearsay reliable. We've just always done it that way, so we kind of still do it. So what's different about expert testimony? And I think the difference is that expert testimony involves something that I call adversarial bias, that expert witnesses are different, not because the expert is an expert or other factors like that, but simply because you're allowed to choose experts in a way you're not allowed to choose other witnesses. Imagine your average tort case, a slip and fall or hit and run. You have a few eyewitnesses to choose from. They may be biased. You can bring out those biases on cross-examination. You have a contract dispute. You have the parties to the dispute, the different executives who are involved, different companies, and that's basically it. When it comes to expert testimony, especially in repeat litigation where there's a lot of money at stake, you have a plethora of experts out there, sometimes thousands of potential experts who would be qualified to testify and who are only going to testify. You're not getting a random sampling of expert opinion. You're only getting experts that the parties want to testify to them, so they know what the experts are going to say in advance. So the example I give from sort of taking it outside the legal realm is, imagine my wife suffers from vestibular migraines, which are migraines don't give you a headache, they make you dizzy. And oddly enough, there's no clinical test to tell you whether you have vestibular migraine or not. It's just you go to your neurologist. If your neurologist knows what they're doing, they could try to figure out if that's what you're suffering from. So imagine that you're suffering from dizziness, and you go to 20 vestibular specialists, neurologists, and the first 18 of them say, you know what, I don't think you're suffering from vestibular migraine at all, and the other two say, I think you are. Well, you're probably going to say, oh, I'm probably not suffering from it, so I'm not going to take any steps. But let's say instead you go to just the top 3 specialists in the DC area, and they all tell you, hey, you're suffering from vestibular migraine. And you know what? There's a new surgery available that has a small risk of making you deaf, but if it doesn't make you deaf, or even if it does, you're not going to have this constant dizziness that you're suffering from, and we recommend that the risk-reward ratio is worth it. You're going to say, okay, I probably do have vestibular migraine. It sounds like maybe I want a 4th or 5th opinion because it's pretty serious to potentially go deaf, but I'm going to at least think that this is what I have. But then, on the other hand, imagine you're my wife or somebody else with vestibular migraine. You just look at the internet. What causes dizziness? You don't know what you have. And you read an article that one thing that may cause dizziness is vestibular migraine. So you decide, I have vestibular migraine, that's it. You consult those 20 specialists, same 20 specialists. The first 18 tell you don't have vestibular migraine. The second of the 19th and 20th say, oh, yes, you do. You say, aha, I'm going to go with those guys and have the surgery. That'd be crazy, right? You'd say, that's only 5% of the experts think that. There's no objective test. What are you doing? And that latter scenario is what we have in the courtroom. The lawyers, both defense and plaintiff's lawyers, they're not looking for the objective opinion of do you have vestibular migraine or did this substance cause the injury? They're looking for someone who will support their preconceived opinion. And again, especially when it's repeat litigation with a lot of money at stake or repeat prosecutions for certain kinds of crimes, it's worth it to seek out those experts who are going to say what you want them to say. So my friends in the plaintiff's bar will often say, well, that's all well and good, but what does reliability mean? After all, reliability in context means, you just look, when there's uncertainty, you go to the experts and you let them try to make the best decision they can given the uncertainty. And again, that's true, but when you're doing that in real life as opposed to the courtroom, you take a random sampling of expert opinion. You go to those 3 specialists. You don't say, I know what I'm looking for, and then go out looking for someone to support your preconceived ideas. So in short, there's been this notion that's been kind of prevalent in some courts, like the Second Circuit, that it's okay to just allow an expert to engage in informed speculation, because after all, experts do that in practice. There's often uncertainty. We need to make decisions. We need to decide whether to do that operation. We need to decide to let that chemical go on the market. And there's uncertainty, and it's okay to be uncertain. Yes, it's okay to be uncertain, but the uncertainty should only be allowed when you're taking the best sampling of leading experts who have no particular stake in the matter. If, on the other hand, as in the courtroom, you're looking for the answer, people to say what you already know you want them to say, and in that context, in fact, you could pay them a lot of money to say what you want them to say, which adds another layer to it. In that context, you need to, it's nothing wrong with allowing people to testify under uncertainty, but they have to have some reliable basis for their testimony. They can't just be speculating. They can't just be extrapolating from evidence of things they can't possibly know. So that's my take. Thank you.
All right, Doug?
Oh, I don't know if, I think Ashley's got that. Can I borrow that clicker?
Yes.
Now we have the counter programming. I did give a comment, I think, opposing this change back in 2022, and dug it up when I saw Mr. Lasker's PowerPoint. This is the language. I have no problem with the first one. Never bothered me before. You have to demonstrate. And in fact, to be clear, in federal court, the other side didn't have to object. If I, as a plaintiff, am putting on an expert, it is my responsibility to show they meet the requirements. Even if the defendant's never said anything, I have to do it, and the same goes for there. So no problem with the first part, but the second part just sounded to me like it was rearranging deck chairs, trying to emphasize reflects a reliable application as opposed to has reliably applied. I read Judge Schroeder's discussion, and really I got caught up just on the part where he talked about what it is that Daubert did, and sort of said, how could you say Daubert liberalized the admission of expert testimony? Well, because that's what Daubert says. It literally says, and quotes good old Judge Weinstein, about liberalizing it, going from the Frye standard, which had a really rigid, this has to be generally accepted, basically a concern of like a cadre of professional experts saying, this is what is acceptable amongst this area of expertise, and that means published, that means we all agree, it means a consensus, and not if there's any kind of deviation, if there's new developments, having that come in. And the Supreme Court in '93 said, no, that's not what this rule is going to do. It's going to actually liberalize it. And the gatekeeping function was not going to be as rigid as the Frye test. And noted liberal, Chief Justice Rehnquist even noted, the gatekeeping function should not impose on the court the obligation or authority to become amateur scientists. And that's why this developed. The referee model was consistent with Daubert. Calling balls and strikes, making sure the expert wasn't nuts, making sure the expert, as discussed in the Joyner case, wasn't making what they call here an analytical gap. A court may conclude that there is simply too great an analytical gap between the data and the expert opinion proffered. This is the ipsa dixit of the expert. This is in '97 in a case where the expert was looking at 4 marginally related epidemiological studies on PCBs and said, yeah, I think this guy's causation was caused that. And the district judge said, no, I just can't abide. This is just too much of a leap. And the Supreme Court affirmed that. So since '97, all those of us who worked in federal court, and I've been there since '95, knew that if your expert was not giving an opinion which was based upon a reliable method or didn't reliably get there, was too far afield, the judge could throw it out. I mean, I didn't know what ipsa dixit was in law school. I sure learned it doing Daubert motions. You're right, Daubert is a bit of a misnomer. In fact, it's not even though Rule 702 for experts, to be fair. It should also include 401 and 403, because sometimes experts repeat themselves, and you could, as another basis for exclusion. So the motion to exclude can actually be broader than 702. But since Joyner, over 6,659 cases I found, in 29,000 trial courts, citing that language about your expert can't ipsa dixit say this is the rule and make this jump. So courts already were able to, and have for quite a number of years, made sure that the expert wasn't just saying things for which there was no basis if it was too far afield. But when it came to judging, like, is this expert right and this expert wrong, and the expert didn't know, judge was going to let that go through unless there was some other, unless there was something basically and clearly false in one of the experts' testimony. Now, the committee noted that the methods underlying the expert opinion, jurors may lack the specialized knowledge to determine whether the conclusions of an expert go beyond what the expert basis methodology may reliably support. The thing is, and you could all ask yourselves this, do you have any better specialized knowledge than most jurors? And in what areas do you have it? Do you have it innately? Are we sure the jurors don't have some knowledge on this? Can you yourselves look at some of this information and say, you know what, I'm sure this person's nice and they present as well, but I think this expert's wrong, I'm just going to toss him. It is likely to be the exception, and it really is the exception, that experts get tossed because they just basically are out left field and they make this jump and out a little gap that's not there. I know that, you know, judges do have a manual. They get the reference manual, at least in the federal courts, on scientific evidence. But if you look at it, it really is just a primer, and some of it's not very detailed. I mean, you know, you get 100 pages on epidemiological evidence. You know, that's really not a lot to basically determine whether or not the epi expert might be too far afield. You have, 50 pages on multiple regressions? I mean, a lot of the damage models here, Sherry Diamond's one on survey research, well, that one is about 75 pages, 65 pages. There's a whole lot of survey evidence out there, especially in the area of damages, which are just not able to be spoon-fed to a judge in the scientific manual. So the judge basically has to rely on the adversaries and the adversary system, and hope basically truth wins out. Judges have, and this is a case, even though the Eighth Circuit is not warm and friendly to me, usually that's always warm to my heart because it reminds that trial courts don't pick the winners. They're not to determine which of the several competing theories has the best provenance. And I have a small example here of a case I had from last year where I had a very, very renowned and expensive damages expert who did a market equilibrium after a conjoint survey, and then a very, very prominent professor at a very expensive other organization argued he had a math error. And that when he altered the code, that there was no evidence of a price premium. And here was the key equation that the judge basically was asked to determine if this was right or not. And this was the one time I got to say to a judge, this is all Greek to me, and literally to everyone. I don't know if you're in any better position than me to say who's right or wrong. And he agreed. He said, well, I have a rebuttal report, and in the rebuttal report, he justified why he did it this way. Their expert said he did it wrong. I can't answer this question. I am going to leave that for the jury. This gets into a question also about each stage, and we'll get to that in a little bit. This was a class certification stage, so it'd be, I think, helpful to point out how at different stages what an expert is testifying to may matter. In some some circuits, when a judge looks at a expert opinion, the judge will do a full-on examination under 702 to figure out if the opinion meets all the three requirements of Rule 702. And others, they have something like, they'll call it a Daubert light, or they're just sort of assess it. Well, does it more, is the person qualified, and would this fit? But they're not going to do a full assessment, and they don't require it. It really still depends on circuits. Some circuits and cases have what we call, in the practice, the IOU report. Like, my expert will do this, and he will figure out, or she will figure out damages. And this is a methodology which courts have accepted. And the court will say, okay, that's all right. I'm familiar with this methodology. I'm not going to make you go through all the steps now at this stage. And it's not clear to me how that's going to work with the new rule, because I foresee that Mr. Lasker will argue, hey, if you're going to meet this new rule, you have to actually go through all the paces, and you can't do an IOU anymore and say, I'm going to do a damage model, where Hal Singer's going to do a damage model and say, yeah, I think I can do it. And Mr. Lasker will jump all over Hal Singer and say, no, you can't do it. That doesn't work in this field, which I think he has, actually.
We reached agreement.
Yes. I like Hal Singer. I'm not on that case, but I like Hal. And this actually, I wouldn't disagree with you, but I'm in a position at a firm where we will pay the money to do the expert report ahead of time and go through that equation. Aside from the fact it helps more with, figuring out a case value, is because I don't want to be sitting that day when that circuit court says, nah, IOUs aren't acceptable. You have to go back and do all your expert work again and lose that case. It's just too high of a risk. Anyway.
Well, now we're going to get to the questions, and the way I'll model this is that one or more of the panelists will respond, but there might be a lead panelist that I will ask to respond first. So I'm going to direct this one first to Alex. All of us just got through the 2015 amendments with respect to discovery. And so we had for years reasonably calculated to lead to the discovery of admissible evidence. And that's been embedded in a lot of the prototypes of discovery responses. And I don't know about you all as judges, but probably for at least over a year after the rule change, I kept seeing that same language. So I want to know, how are we communicating this, not just to the public or the lawyers, but even to the judges, that this is no longer the standard?
That is a great question, and I'm not sure anyone knows exactly the answer, but you're exactly right. That language about the scope of discovery kept showing up for years after it had been eliminated from 26B1. And it is entirely likely that there's going to be a little lag on this issue after December 1st, which is the date that the amendment we've been talking about will come into effect. I think the reality is that not everyone, every judge and every lawyer in every jurisdiction is going to pick up the rule on December 1st and read it and change all of the opinions. But that is what is meant to happen, of course, that the rule language will change and the practices should change of that date. But it is a matter of judicial education, and individual courts and others should be making sure that everyone understands that the rule language has changed. And of course, there's a huge burden, perhaps even more so, on counsel to understand that the rule language has changed and to incorporate those changes into their arguments before the court. But I think that as much as I hope that everybody reads it and we don't see that lag, I think that it's more likely that we're going to see some courts take their time to understand the new changes, even though they should be on it.
And another one I'd ask you about, because you spent a lot of time with the amendments, even on the state side. There are several states, maybe up to 15 or so, who have not agreed to adopt this rule. So that adds on to this layer of misunderstanding where the rules should be applied.
Right. I think there are a number of state rules that are either identical or pretty close to the federal rule, but there are exceptions, as you noted, and I do think that the same dynamics that led to this amendment are alive and well in almost all, if not all, states. So I do think that all state rule makers, and that's courts in a lot of places, courts or legislatures or a hybrid between the two, really ought to look at their state rule and examine whether there are problems equivalent to the kinds of problems that led to the federal amendment.
And Professor Bernstein, and then also Eric, I gave you credit early for kind of the impetus for this rule. And just like technology, once it's out, it's old, it's obsolete. So I just want to know, do you already foresee just kind of some issues related to this rule that we'll be working through, despite the rule doesn't go into effect until December 1st?
You know, I tend to, I have a theory that one reason why the 2000 amendment was largely didn't get into judicial consciousness was that for those of us who remember what was going on in December 2000, everyone was obsessed with Bush versus Gore. And as soon as that calmed down and people got back to business, we had 9/11. And then everyone was worried about the security of their courthouse, and a lot of other things. And it just wasn't the first thing on judges' mind. And feels it just basically incorporates the trilogy anyway, so we're not going to ignore it. So I think that won't be the case here in the sense that there's nothing quite as, hopefully there will not be anything quite as dramatic as either of those events going on, and there's already judges already talking about it. I think there is an underlying problem with the structure of 702 that was not in our article, has not been addressed in by the advisory committee, which is that it works pretty well. I think it could work very well for a lot of kinds of expert testimony. There is one kind of expert testimony which I've referred to as connoisseur testimony, where someone comes in and says, I don't have an objective basis for my testimony, but I just know because I've been doing this for a lot of years, and that's a valid kind of testimony, but you don't really, but it's under the rule, it seems like it should be excluded, but that can't be right because my favorite example, I heard this from a judge in Iowa, that they had an expert, there was some issue involving whether some local construction was disturbing the cows on local farms, like as a nuisance. And they brought in a local farmer as a cow moo expert who said that his cows were expressing their distress in their mooing. And how did he know this? Well, he's been a farmer for 35 years, and he knows the difference between a sedate cow and a distressed cow. And I'm not sure how you'd apply the reliable methodology, applied reliably, et cetera, to that sort of circumstance. But it can't just be that we never let cow moo experts in. So I think there's something that still needs to be addressed.
I've not had a cow moo expert. I've had other experts that have been interesting. I think there will be some continued difficulties with the rule because of the reasons that Doug and I both referred to, which is this is a tough one. I mean, this is not an easy rule for judges to apply. And there will be, I think, a tendency for some courts, for some judges who, may not have had, like me, a science class since 11th grade in high school, to jump into the fray here, and they will be happy to not take that on. That doesn't mean they shouldn't, and they're being told, certainly under the federal rules, that they have to. That's part of the responsibility of the court. I am actually sort of evangelical is the word on this, but I think that the courts have a role here in taking a stand against the politicalization of science, the skepticism about science that I think is throughout our society. But I don't suggest it's easy. I don't want to suggest that there's always going to be an easy thing for judges to do, but it is a very important part of the judicial process. And if it's not done, I think it results in improper justice in a whole variety of different ways. So it's hard, and because of that, I think there'll be lots of courts that don't do it, but I hope that they do, and I hope this makes a difference, and I frankly have told my kids that I feel like I've potentially made a difference if it does, myself.
And then Alex and Doug, Alex, you mentioned earlier that you all had conducted a 2020 study about the 65% of cases not referring to the rule. But then also, when we were prepping for the discussion, you mentioned that you're not seeing judges actually give an analysis of why they're letting things in or not. So I'd ask Alex and Doug, what do you expect that to look like now? You're not calling it a Dahlberg hearing, so what do you expect judges to have this look like? Number one, is it going to be a 702 hearing? Are you going to have some initial, even if it's just a few paragraphs, order to put in why or why you have not, for guidance for future courts? I mean, what are you all expecting of us?
Great question. I think the answer is that a greater paying of attention to the standards, and by that I mean the standards of Rule 702. The study that I mentioned, all the federal cases, there are 1,059 federal
You're going to blame this
opinions.
just on the federal judges?
Well, no, of course not, but these happen to be the ones we studied. But there were 1,059 federal opinions in 2020 that had some relationship to an expert admissibility decision. What I mentioned is that 65% of those did not mention the proponent's burden of proof or the preponderance standard. Now, that doesn't mean they got it wrong. It just means they're not even referring to the standard. So 35% of the cases did mention the standard. So a third of the cases mentioned the standard. But the other two aspects I'd like to share, 13% of cases used language that is actually wrong under the rule, saying that Rule 702 has a liberal thrust favoring admission rather than a preponderance standard that there is a burden to show before admission. So 13% were saying something that was in opposite of the rule. And then, maybe most remarkably, 6% of cases cited both, that there is a preponderance requirement and a preference under the rule to allow admissibility, which is entirely inconsistent. So I think what we will see, fingers crossed, is that courts will focus on Rule 702. They will walk through the analysis, and what we'll see is a lot more references to the rule and a great deal more consistency with what those standards are, how they're applied to cases coming from the rule as opposed to the case law that has the problems we were discussing earlier.
So I think a lot of judges, just like a lot of lawyers, and this also goes to the question about rooting out the likely to lead to discoverable evidence, we recycle opinions, we recycle briefs. We just work off of the same template, and sometimes it has the same outdated language. And I recently, in a case filed in the District of South Carolina, regarding experts in a case called Blackbaud, I had cited a case, and I had it handy, as it turned out, called Funderburk versus South Carolina Electric and Gas. And the very learned judge in it did a very, very good job in looking at one of the experts who basically was relying on basically an industry ad about how culverts degrade to say this thing must be this fault. And what that judge did is, I would say, consistent with both Rule 702 and also with Joyner, and say, can you get there from here? And this person, it's like the basis of his opinion was something from the manufacturer. There was no indication as to how they tested the metal or whether the metal was going to fail or when it would fail. But the expert said, well, everybody knows this metal is going to corrode, therefore this was FSX fault for not replacing this culvert sooner. The judge said, no, that's just not enough of a basis. You failed the methodological test and didn't excluded it. And yay for that judge. But you can, I think if you always approach your briefs in here, and any practitioner who has any idea what they're doing here is going to start out by saying to the judge, this is the standard. I cited the standard for Funderburk in my brief, so it had those three elements, and then worked off of it. You should have that knowledge as a litigant. Hey, work off of the judge's opinion in that area. And for the judges, they may have to dust up their standards and make sure it's consistent with this. But I have not seen too many judges. I mean, notwithstanding what you saw, I haven't seen too many judges that don't have that trinity of qualifications, methodology, and fit. I mean, it's like beat into you. But to the extent they're not, then I think they're going to be in for a rude awakening from appellate courts. And some of the appellate courts will jump on this and remind them.
And then I want to move back to you, Doug, because you do a lot of multi-district litigation, and without getting into the weeds of the Blackbaud case, when I was there, one thing we did to get you all started, very expedited, I had a motions practice where I only allowed motion and response. They had so many days to brief it. on, you know, your typical checkoff motions, jurisdiction, standing, et cetera. And then I'd rule, you know, within 30 days. And then we went to the next set of briefing, which was, okay, let's talk about all your common law claims. Same thing, motion response, and then I'd rule. And then we went to the statutory claims because there were over 95 or so. But then we got quickly, within 6 months or so, what's in the case, who's in the case, and all of that. So now they've gone rogue. Because my understanding, no, I'm just messing with you, is that they are now at the class search stage, and there's at least 5 experts on each side. And so you have a judge who has to weigh all of that. So talk to me a little bit more about the court-appointed expert potentially. Is that an option for judges now with the new rule? It was already there, of course.
Right.
But with the new rule and then having to manage all of that.
Okay, I'd be remiss if I didn't point out that, first of all, the decision to break it up the way you did, especially on choice of law, for someone who does multi-district litigation that covers a lot of states, I wish we had done that in our Marriott data breach case, because when it went back from the Fourth Circuit, that was really the issue of, well, wait a minute, Judge, you didn't really decide whose law applied. So we went through the whole process, class, 23F, argued appeal, and we're right back to deciding
And
the
there's a
issue we
lot
should
of
have decided
time.
for.
Yeah.
So that was very handy, and it's something now in all my cases, I advocate, let's settle this before we get to the class search stage, everybody. But on the expert issue, you know, and I skipped over it in my presentation because you mentioned this question was coming. It always has been an option to do what we call a hot tub, you know, where you have sort of everyone's in the hot tub chatting about what are the issues, and the judge could bring in his or her own experts or have the experts show up at the hearing and ask and sort of evaluate them in person. Like, who? Okay, I read their reports, I've seen some of the deposition transcripts, I've seen the briefing that says this person's an idiot, this person's a liar. Let me actually hear from them and see what I think of them. And maybe I'll get my own expert who could weigh in. That's always been an option. It might be one that judges are more inclined to do if they know they're not just being expected to let the jury sort out between the litigants, that they want to make sure that they're meeting their obligation. Of course, it tends to increase the cost, and I'm sure there'll be some judges who are concerned, well, who am I bringing in? How am I know that my expert is, quote, impartial? And am I just opening myself up to appeal where someone's going to say, the judge brought in that expert was wrong? In our Marriott data breach case, Judge Grimm did bring in an expert and his own economist, and his own economist said, I don't agree with plaintiff's economists on this, but I'm okay with this. In some ways, I got to say, as a litigant, it makes it that much easier if at the end of the day you say to the other side, look, the judge's own expert let this in, can we resolve this somehow? So it will be interesting to see how it goes.
Then you've talked a little bit, and meaning the entire panel, about credibility, politicization of the expert testimony, and then how we're grooming jurors because they ultimately will make the decision with respect to the verdict in the case. Very few states allow voir dire by the lawyers. The judges generally conduct it, and of course, they allow the lawyers to participate in it by giving their written submissions in that regard. But how do you plan on affecting jurors in this regard in terms of their mindset toward your case, in terms of credibility and their ideology about the case? And I premise that question because you all remember COVID. It was such a battle of the experts about what should we be doing as a society. And I think that has called to question even more expert testimony because we had that battle at a political level in that regard. So my question again is just more about how are we grooming jurors in terms of their mindset about how they should view this evidence?
That's really tough, and I was reminded about a law professor who had once predicted 5,000 people would die of COVID, and he was wildly wrong. It's a really hard question to figure out how to gear a jury into saying, you know, you're going to hear from my expert, you're going to hear from their expert, keep an open mind is the only way. And I was reminded by someone, because I used to practice in Brooklyn in criminal courts, and when I was there in Manhattan, the prosecutors would say to the defense attorneys would say to the juries, you're going to hear from some police officers, would you just give them the same credibility you give to everyone else? And in Brooklyn, the prosecutors would say to the juries, look, you're going to hear from some cops. Will you just please give them the same credibility you give to everyone else? The juries were, no, they're not going to do it. So it really is going to be, I think, a jurisdiction by jurisdiction kind of a thing of how you warm them up to these concepts.
So I guess my view of this is that's why Rule 702 is important, because the jury should not be receiving scientific evidence or expert evidence that does not at least pass the reliability standards that are set forth in 702. Certainly, you know, the attorneys need to advocate their case, and the judge will present the case and tell the jurors to keep an open mind of the evidence that's put in front of them. But 702 is intended to protect jurors from evidence that they shouldn't rely upon. And, you know, in a lot of these cases, expert testimony deals with very emotional issues on the criminal side, on the civil side, where people have political views, and they're going to come at it from that perspective. And those are valid bases to make decisions, but they should be valid bases to make decisions relying upon evidence that is properly before them. And so the issue of 702 is, and I think may be differing for different rules, but I do think judges have a responsibility to protect jurors and present them with the evidence that is reliable for them then to bring in whatever different viewpoints they have to view on that evidence to make a decision, but to be making a decision on sound evidence.
Okay. Anyone else want to comment?
Yeah, you know, I have a little bit of an idiosyncratic view when I teach evidence. So I teach the character evidence rule, 404 of the federal rules and most state codes, which, as you know, is a propensity rule. So you're not supposed to bring in evidence of past crimes to show that the defendant has a propensity to commit such crimes. I always tell my students, well, that's the traditional reason that we give for the rule. And my idiosyncratic view is there's another reason which may even be more important, which is that imagine you have a criminal defendant on the stand, and you bring in the fact that he's a 25-year-old defendant. He's already engaged in 8 bank robberies in the past, and he's accused of bank robbery right now. Now, if you're a juror, you might very well say, I don't care whether he's done this particular bank robbery. What the heck is this guy doing out on the street when he's already engaged in 8 bank robberies? So I'm going to either really lower my standard of proof or not have one at all. I just want him to be in jail, which, you know, is lay justice, so to speak, but it's not the way our system works. You go to jail only for the crime that you're being accused of. So similarly, with regard to expert testimony, both criminally and civilly, we want to make sure the jury is not just able to shift the burden of proof and whatnot, so we just let all the evidence and let them decide. There's a lot of evidence in toxic tort cases, for example, from jury surveys after the cases, that a lot of times the juries would say, well, you know, look, the defendant acted badly here. They had a chemical spill. This other person has leukemia now. Why not just shift the burden and make the defendant disprove it? Well, that may or may not be good policy, but it's not the law. Or in criminal cases, you know, a lot of times the criminal defendant, even if they're innocent, why they picked up to begin with? Well, they associate with a lot of really bad people. And they seem like the kind of people maybe we don't want on the street. So we want to make sure the prosecutor is actually presenting sound evidence. The jury isn't just putting someone away because they seem like a kind of person who should be in jail. So I actually think that it's really important to try to focus the jury's attention, including via the rules of evidence, on whether there is sufficient underlying evidence in the case to prosecute or win the civil judgment, and not to let them get too much into their own internal biases of who they think is right or wrong.
All right, and then Alex, when we're talking about this gatekeeping role, we keep focusing on pretrial, but that role continues on even during the trial, correct?
Right, that's the import of the third of the amendments, the second sentence in the amendment, that is meant to, the Rules Committee called it overstatement, to prevent the overstatement of an expert saying that, opining that the evidence had a bigger effect than it actually does. And they talked particularly in the forensic science area, the examples they used were fingerprint science and ballistic science, where a description of the methods of those disciplines would say some kind of reliability standard. I don't know the numbers, but let's say it's less than 100. But after walking through the meaning of all that to a jury, an expert might be asked, do you think this was, or, how certain are you that this is the defendant's fingerprint or this was a bullet from a defendant's gun? And they'll say 100%. And so what the committee is really interested in for this amendment is that overstatement. But I think that what that means is that the gatekeeping responsibility of courts is ongoing, that it's not okay to say that person is a ballistics expert, therefore they can opine. Even if that person is a ballistics expert, that person must keep opinions within the realm that are based in the facts of the case and the recognized principle or the principles of the methods that they're using to evaluate those facts.
And then also not to go beyond that specific expertise that they were qualified for.
Right.
In other words, sometimes you may need more than one expert in that particular case to go a little beyond that. All right, we have a time for a few questions. Are there any out there? You all are ready for December 1 and Ruth 702.
Judge Howard, you
Oh,
talked.
thank you.
You talked about the courts expert, but my question is about the use of teaching experts, because I've seen it in Atkins appeals on the criminal side, where one side or the other brings in a teaching expert that talks about the methodology for testing, the reliability, what the results means, but they will never opine on the ultimate issue. I understand about hot tubbing, and my view of hot tubbing is you just bring a bunch of people into a hot tub, and it's a toxic mix of bacteria. What do you think about the use of teaching experts in civil cases?
So I can start off, because we've used that many times. We call them science days. And both, the plaintiff's counsel and the defense counsel will agree to certain rules. There's no ultimate opinions presented. It is just discussing the methodology. Oftentimes, in those situations, the experts are actually pretty close in explaining what the methodology is. So that does, I think, provide the court with a good opportunity to learn what the methods are and how they're supposed to be applied, and sort of educate the judge going into the 702 challenge. So I think that's a very useful approach.
Absolutely agree. And sometimes we've done science days, like at the Rule 26 in federal court, their initial status conference. We will bring in, as part of it, we'll have one of our experts, usually a background expert, won't be testifying. Defendants will have their own expert, and they'll just say, like, here's how these engines work. Here's how the cybersecurity is. We'll have someone who would just go over the basics and not, opine on anything or basically suggest anybody was wrong, just so the judge has an idea of what the case is, and the judge can figure out going forward, what do I need to do for scheduling, where could this go? But also gives a basic understanding of what the issues are.
If I could
Sure.
just weigh in here from the academic point of view, I think it's a little crazy, even though it's always been the way we do things. Everything like this is always done orally without the jurors being able to weigh in at all. So to the extent it's allowed in your jurisdiction or not, or at least not prohibited, I think in these teaching days, after, towards the end, do jurors have any questions? And they can either be, could they ask directly or at least submit the questions to the judge to see if there are, because I'm sure some jurors would ask wild things, but just, so why have that whole teaching day if all the jurors are stuck on one point they don't understand, but they're never allowed to let that be said? And I actually think it would also be fine if you could get the parties to agree on whatever basics they agree on, and then give the jurors some written document that they could then look back to when they're trying to understand the expert testimony. To expect people who have no expertise, no prior background whatsoever to the subject, to be able to follow weeks or days or weeks of oral testimony on complicated issues without anything in front of them to help them, just strikes me as preposterous. But I know that's how it's done, but just doesn't seem right.
And then some of the jurisdictions, people aren't allowing even note-taking, so it even amplifies that.
So my question is on behalf of the state court trial judges in smaller jurisdictions on cases that are more routine and not the novel or the terribly complex, say a forensic accountant or a bullet comparison or fingerprint comparison, the stuff that we see on a day-to-day basis. in our jurisdictions, these 702 hearings are becoming weaponized. They're becoming discovery hearings when we don't have discovery in criminal cases. And we see them as like test runs for cross-examination for their jury trial. And I find myself, in my opinion, wasting a lot of time relitigating 702 on, the same 4 or 5 expert witnesses from my local police agencies or the same psychiatrists from the state hospital that are there. How summary can we be in a 702 hearing? And, what can we do to rein some of these more routine issues in so that we have the complex matters, we can have full 702 hearings?
Personally, I was just going to say that on some of that, particularly when you see the repeat experts and the repeat issue, you've already ruled. And to the extent you pull your old transcripts and say, this is how I've done this with this particular person, it's a new case, it's a new day, but my answer hadn't changed, then I would purport to put that out there.
Yeah, I would just say, you can't stop. I would say, is there something new? That you have some new evidence of why this technique has now been shown to be unreliable. If not, I just got a little hobby horse I have. One way that this could be streamlined somewhat is there have been efforts to have the Justice Department, the U.S. Justice Department, do studies of how reliable are these forensic techniques, when are they reliable, what are the error rates, and everyone would know. And the Justice Department has consistently killed this because they don't want to know, which is very disturbing.
I would have to say, though, for some of the forensic stuff, it's not, the technique and fingerprints and a lot of the stuff is known. It's the application. And I have a vivid recollection of being in a criminal case with a colleague and the detectives talking about, well, I know this person could have done this because based upon the crime scene photo, the blood congealed 5 hours ago, so that, knocked out his alibi witness. It was one of those things like, well, we needed to know that information beforehand. So immediately we had to pause the proceedings and got Henry Lee on the phone, and Henry Lee said, oh my God, you cannot do that from a crime scene photo. So sometimes if you have a hearing to air that stuff out, it is absolutely discovery, but you gotta know not just, is this a proper techniques, but is it being done by someone who's, saw a class or watched a couple of episodes on CNN? Do they actually know what they're doing? So it might just be the old criminal lawyer in me, but, I think that there is the utility to that. And I'll shut up because I saw the no time left sign.
Okay. Well, thank you all. Thank our panel, please. Thank you.
Thank you very much, Judge Childs, and thank you to our panelists. We'll break for 15 minutes. Please be back here by 3:30.